Hello and welcome to Part 7 of Compliance Briefs on Client Due Diligence, where we will focus on the economic profile of the client. In this part of the Compliance Brief series, we'll be focusing on the concept of the economic profile as part of client due diligence. We'll start by looking at what an economic profile is and why it is such a key element of CDD. Then, we'll explore the role of the economic profile as a risk management tool, helping firms assess and document client risks. Next, we'll cover when to prepare or update an economic profile and move on to how it should be prepared, including the standards and sources of information that should be used. We'll also look at practical aspects, such as documenting the profile, simplifying its structure, and identifying the entities and individuals involved. Finally, we'll see how the economic profile is used in practice when monitoring transactions, especially in the context of administrative services. An economic profile provides a comprehensive overview of a client's business and financial background. It typically includes the declared business activities of the client, the economic rationale behind those activities, the expected transactions and turnover, both in volume and frequency, the client's main business counterparties, including its major suppliers and customers, as well as the jurisdictions of operations. The economic profile forms an essential part of client due diligence. But it is so much more. The economic profile is an integral part of each firm's client acceptance policy, providing the foundation for assessing whether a client fits within the firm's risk appetite. A well-prepared economic profile not only supports regulatory compliance but also strengthens the firm's ability to provide effective services. By maintaining detailed knowledge of a client's business activities, financial background, and the purpose and intended nature of the business relationship, the firm is better positioned to identify unusual or suspicious activity. This is particularly important when services involve the processing of transactions, where more detailed information and a comprehensive profile may be required. The economic profile is a memo or document that each firm is required to create for its clients. It serves as a comprehensive record of the firm's understanding of the client, by reference to its financial background, sources of economic means, and ordinary transaction patterns. To develop this profile, information should be collected from a variety of sources, both from the client directly and from reliable open sources. The resulting document constitutes the client's economic profile. The economic profile should demonstrate a thorough understanding of the client, provide information that supports the risk assessment, for example, sector of activities, countries of operations or association, transactional behavior, and methods. Serve as the foundation for the firm's transaction monitoring system. Reduce the risks the firm is exposed to and help prevent reputational and financial damages. Form the foundation for the firm's overall conclusion on whether to accept, continue, or terminate the client relationship. The economic profile of a client should be prepared at the outset of the business relationship. It must be kept up to date, with reviews scheduled in accordance with the firm's periodic review policy. Updates should also be made following a triggering event. New or material information becomes available. Significant change in client circumstances, unusual activity, or adverse media. Doubts arise regarding the accuracy of previously provided information. Suspicion emerges of potential money laundering or terrorist financing indicators. The economic profile should not be treated as a static record, but as a dynamic document that reflects the most accurate and current understanding of the client at all times. Firms may prepare the economic profile in different ways. As a free-form memo, drafted from scratch and incorporating relevant information, analysis, and conclusions. Through the use of risk assessment software, by generating an automated document and supplementing it with additional information and professional analysis. However, care must be taken not to over-rely on automated tools, as this can result in incomplete or poor quality profiles. Ultimately, the format of the economic profile is less important than its substance. What matters is that it contains all necessary information and analysis to demonstrate a clear, well-documented understanding of the client and to support sound decision-making. The extent of information documented in the economic profile will be driven by the risk-based approach, and as the understanding of the client is developed, the extent of information and evidence required will be determined. It is not expected to apply the same procedures to all clients. The information and understanding recorded in the economic profile should be substantiated and corroborated in line with the firm's risk assessment. Firms should be careful not to accept client explanations at face value without further investigation or without collecting supporting documents. Firms should not over-rely on unverified information. The Internet will of course be a source of information and corroboration. However, firms should be able to demonstrate that they have considered the validity and reputation of the sources used. A good starting point for documenting the economic profile will be the clients themselves. Whatever the form of these representations are, such as questionnaires or meeting notes, it is best to be signed by the client. This increases the validity of the representations and provides accountability. Typically, a questionnaire or information memo can be created to collect information regarding the corporate entity, which could be signed by a director or another person with the mandate to represent the entity, and one for each beneficial owner signed by the individual him/herself. According to ICPAC's AML, CFT, and sanctions directives, there are specific pieces of information that must be collected for every client. First, firms need to establish who the client is, along with who owns the client, tracing the chain of ownership all the way to the beneficial owners. It's also important to identify who controls the client, particularly in cases where control is not exercised through ownership. Next, firms must understand the purpose and intended nature of the business relationship, as well as the nature of the client's activities or business. Information should also be gathered on the size of the client, their source of funds, and where necessary, of wealth, and the overall business and economic purpose. The client's group structure should also be documented, including any subsidiaries, associates, or related companies, especially those with which the client regularly transacts. Finally, firms should assess the commercial and business rationale behind the client's existence and whether it can be demonstrated that the entity exists for a legitimate trading or economic purpose. All of this information should be clearly documented in the client's economic profile. The economic profile can be simplified into 4 key areas that form a practical structure. 1. Identification of entities and individuals. 2. Sufficient understanding of the client activities and transactions. 3. Size and source of funds, and where necessary, size and source of wealth. 4. Economic rationale. As a starting point, the entities and individuals subject to KYC procedures should be identified. The process begins with the client. Where the client is a corporate entity, the firm must establish a clear understanding of the chain of ownership up to the beneficial owners, as well as any subsidiaries, associates, or related companies with which the client transacts. This can be achieved by obtaining the client's full group structure and confirming it through supporting evidence such as corporate certificates, public registers, or other reliable documentation. Even if a client is only dealing with some entities in a group, the existence and nature of the wider group structure may still have an impact on the firm's assessment of risk. The firm must also document who controls the entity, particularly in cases where control is exercised through means other than ownership. In addition to beneficial owners, shareholders, and directors, firms should consider any other individuals for whom information should be collected. This includes persons with the mandate to represent the client, such as signatories or individuals holding powers of attorney. Beyond standard KYC procedures, firms should assess whether such individuals have a legitimate authority to act on behalf of the client. Gaining a sufficient understanding of the client activities and transactions means documenting and corroborating the client's activities, describing the country of incorporation and countries of operations, as well as the main counterparties involved such as suppliers, customers, and bankers. Additional information to be documented include the nature, size and frequency of transactions, as well as key financial information such as total assets, revenue, total loans receivable and payable, the share capital and other injections such as share premium. Merely collecting the supporting information and using open sources does not equate to understanding the activities and transactions. Instead, consideration should also be given to the history of the client to identify any changes which might be unusual or not in line with expectations. Furthermore, an analysis of the information to assess validity and reasonableness should be done. For example, would it be reasonable for a client to establish a business in Iceland selling summer clothes? The understanding should also extend to the other companies in the group structure, in particular if the client transacts with these related entities. Firms should be alert to risk factors that might appear by considering high-risk activities and transactions within the group, the overall business model and the nexus which may exist between the entities. Finally, firms should bear in mind and document any consideration of matters such as sanction regulations. When documenting the economic profile of a client, the size and source of funds and wealth plays an integral part of the overall understanding of the client. A core part of the economic profile has to do with the size and source of funds and, where required, with the size and source of wealth of the beneficial owner. It is important to clearly distinguish between the source of funds and the source of wealth. If the client is a corporate entity, attention should be directed to the source of funds used by the entity in its operations and how the entity has built its entire wealth. In order to do so, the activities already documented in the initial stage should be linked to key financial information which can be collected from the audited financial statements or management accounts of the client. It should be clear that simply recording information without proper analysis is not sufficient. As a second step, firms should examine any additional funds received by the legal entity, which may take the form of loans received either from financial institutions or funds received in settlement of loans already granted by the clients. Other sources such as donations and grants. Injections from the beneficial owner's own funds. Proceeds from the sale of assets or investments. It is important to ensure that the economic profile also includes how the information collected is supported. Generally, establishing the source of funds should be more straightforward than source of wealth, but this should not be restricted to knowing the country of origin or the financial institution the funds may have been received from. The source of wealth is more complex as the source may come from several sources and may have been created many years ago. Information and supporting documents should be collected on risk basis, including deed of sales, salary records, tax returns, and financial statements, and can be obtained both directly from the client as well as through open sources. The Internet can always be a source as long as the reputation and validity of the sources is checked prior to relying on such information. For a more detailed explanation of this topic, please refer to Part 6 of the Compliance Briefs series on client due diligence, as well as ICPAC's publication guidance on establishing source of funds and source of wealth, available under the Monitoring and Compliance tab in the Compliance Guides section of the ICPAC website. This part of the economic profile should consider the business and economic purpose of the client. It is important to assess if the information collected makes sense and there are rational reasons for the existence of the client, in the form it is set up, including legal form, jurisdictions of operations, structure, etc. For example, consider whether the activities of the client are in line with the knowledge, experience, and background of the beneficial owners or directors of the entity, or could it be part of the overall tax strategy of the beneficial owner. Consideration should also be given to the legitimacy of the transactions. Firms should assess whether the transactions are consistent with the established understanding of the client, appear legitimate, and align with the expected profile. Any changes that seem unusual, inconsistent, or unexpected should prompt further inquiry. Remember to always ask why. The final area to be considered is how the economic profile impacts the transaction monitoring of the client. The term transactions may refer to signing of contract, bank transaction, power of attorneys, signing of resolutions, etc. Monitoring of transactions is especially relevant when a firm provides a client administrative services under the ASP law, such as directorship and bank management services. The economic profile should form the baseline for transaction monitoring, the assessment of transactions, and the identification of abnormal transactional behavior. It provides the guideline that will help the firm set up transactional thresholds that would generate alerts or flag transactions that deviate from the expected for further investigation. For example, based on the information included in the economic profile, benchmarks in relation to amount, frequency, counterparties, suppliers are created that trigger alerts when transaction characteristics do not align with the established economic profile. Firms can use checklist each time a transaction is executed on behalf of their client. A guide on transaction monitoring and relevant checklists is available on ICPAC's website. Part 8 of Compliance Briefs on Client Due Diligence will cover the transaction monitoring. I hope you found this useful. For any queries, you may contact us at compliance@icpac.org.cy. Thank you and goodbye.